Did you know that a single missing sentence in your non-disclosure agreement could cost you double damages and attorney's fees in a federal trade secrets lawsuit? Many entrepreneurs think their basic NDA is enough, but to secure the most powerful protections available, you need to be DTSA compliant. Stay tuned because that single sentence is the difference between federal protection and potentially losing your most valuable business secrets. Welcome back to Beyond Formation, your legal roadmap for the first year of business. My name is Maritza Shay Nelson, and I'm a small business and nonprofit attorney. I help entrepreneurs, founders, dreamers, and innovators pursue their passion without worrying that legal stuff, like a missing sentence in your non-disclosure agreement, might come back to bite you. Any confidential business information that gives you an economic advantage over your competitors is potentially what we call a trade secret. And trade secrets are a type of intellectual property. They are just as valuable as your copyrights or trademarks or patents, but unlike those types of intellectual property, trade secrets are not registered. You see, the law doesn't really protect ideas or information. If someone else can see what you're doing or how you're doing it, then legally they're allowed to compete with you and try to do it better. So if you really want to protect your business information, then you have to put in the work to keep that information secret. It's the secrecy that makes it a trade secret and therefore legally protected. And for that, we use non-disclosure agreements or NDAs. Every single person or entity, whether we're talking employees, independent contractors, customers and clients, or strategic partners, should be required to sign an NDA or have confidentiality clauses built into their agreement with your business. A good NDA clearly defines what is or isn't confidential, obligates the party receiving confidential information to actually keep it secret, and perhaps most importantly, defines the consequences of a breach. To truly be effective, NDAs and confidentiality clauses need to incorporate specific notice language mandated by the Federal Defend Trade Secrets Act, or DTSA, of 2016. This notice informs the recipient of the information that they are immune from liability if they disclose a trade secret solely for the purpose of reporting or investigating a suspected violation of law, either to a government official or to an attorney. It also covers disclosures made in a court document filed under seal. Now, you may be thinking, why would I want to tell someone that they can use my confidential information against me like that? Because if you don't include the precise notice language that the DTSA requires, then your business gets cut off from significant federal DTSA remedies. In other words, if you comply with the DTSA, then you can potentially be awarded double your damages and the attorney's fees of bringing that case. So integrating this notice isn't just a best practice. It's a prerequisite for maximizing your potential legal protection. While NDAs protect the secrecy of your information, other restrictive covenants can protect your business stability by limiting where and how your former team members can potentially compete after their departure. These should be considered for essential team members who possess deep knowledge of your operations, client base, or strategy, but implementation is contingent upon strict adherence to state and local laws. First, non-compete agreements. These prevent a former employee from working for or starting a competing business within a defined geographic area and for a specific period of time. Now, be warned, their enforceability is highly dependent on the governing jurisdiction. In other words, what law governs that particular contract, and in some cases, where the employee is actually based. So while non-competes are falling out of favor in many parts of the country, they are still enforceable here in Ohio, as long as the restrictions are not considered overly broad. So this makes careful drafting absolutely critical. Second, your non-solicitation agreements. Now, these are generally viewed as less restrictive than non-competes, which makes them much more likely to actually be enforced by the court. And they serve two primary functions. Oftentimes, they prohibit a former employee from soliciting your clients or customers, again, for a set period of time. but they also will prohibit your former employees from soliciting or recruiting their fellow coworkers or former coworkers to leave to go to their new venture with them. These covenants, when used in conjunctions with NDAs or confidentiality clauses, form the basis for protecting your business's proprietary information through its critical first year and beyond. Protecting your intellectual property, especially critical business information, is not a task that you just check off your list one time. It's an ongoing commitment that requires good contracts and employee training. My clients range from startups to growing businesses and nonprofits with nearly 100 employees across a wide variety of industries. If you have questions about confidentiality, non-compete, or non-solicitation clauses, then let's talk. Check out the link in the description to schedule a consultation. And if you're not quite ready for a consultation, grab our free post-formation legal checklist to start auditing your own setup today. It's a great way to map out all the critical legal protections your growing business needs right now.